Hello, this is Heather with Bootleg Legal, and today we're going to talk about your COVID reopening plan. Now that businesses are starting to be allowed to open in the state of California to varying degrees and in varying industries, but there's a lot of information out there, and then there's a lot going on behind the scenes that probably most business owners aren't even privy to, but could still come back to bite them. So I'm going to go through a quick few things that every business owner should know as they start to either reopen or develop a reopening plan for the next coming weeks. Okay, so first, some good news. Waivers. And waivers simply says, I know that there's a risk of contracting this while I either use your service, shop in your store, and I am willing to take that risk to use this service. So I had a lot of clients request these, and I did a lot for clients, but none of us really had a clear idea of whether and to what degree that they would be enforceable. But now there's some expert opinions circulating stating that they should be enforceable as long as a few things are met, a few requirements are met. And those requirements are that it's a non-essential business, meaning, if you are the only dentist in town and somebody has a dental emergency and you require them to sign a waiver in order to, get that root canal, your waiver might not be upheld as enforceable. But for basically anyone else whose service is not essential, it's not necessary for somebody's life, or even if it is somewhat necessary, like a grocery store, there are other stores that they could go to, right? And so the key here is that they have meaningful choice. Do they have meaningful choice to not come into your place of business? And if so, then having them sign a waiver to come into your place of business is probably going to be upheld. You're not going to be able to waive your own gross negligence or willful misconduct, but hopefully you wouldn't want to. But you are able to waive your own negligence. And I know it sounds super weird to have your clients or customers sign waivers before they meet with you, and people may balk at that, but I predict that most of the large corporations in big cities at least start adopting waiver policies. And once they do it and they kind of normalize it, I think you'll see it in small businesses. I just hope that in that period between when it's normalized and small businesses adopt it, that not too many people come into the small businesses and contract it without a waiver to protect themselves. Okay, waivers. Now, force majeure clauses. I've talked a lot about this throughout the pandemic. Force majeure clauses basically say, hey, if this thing that happens that's out of our control, be it a war or earthquakes or tsunamis or tornadoes and now a pandemic, if this occurs, then, the parties don't have to perform. So prior to COVID-19, people gave no thought to force majeure clauses. They were included like half the time they weren't. It just had not happened anytime since really World War II that people really needed them. And so they're definitely a legal afterthought, and now everybody wants them. But this is what you need to be careful about. You can't just put any force majeure clause in there. You want to make sure it's precise. What you don't want is for there to be a force majeure clause that gets the other party out of paying for something you've already delivered or services you've already performed. So if it's a blanket, like the parties don't have to perform in a pandemic, that's going to be problematic. You just want to carve it out, and you want it to be sufficiently specific as to when the parties can either delay performance or forego performance altogether. And so I strongly recommend getting the help of counsel, because even though you may think you need a force majeure clause, it's just as likely that it could be used against you. And so you want to make sure that, because these clauses, of course, are usually mutual, and so you want to make sure that it's written in a way that it's only going to terminate a party's obligations under the contract under circumstances that you would like it to terminate those services. So, a mild flu season or even a, intense flu season, you don't want that to be just grounds down the road for someone to say, it's a pandemic. I don't have to perform, right? So being careful and being thoughtful. Don't just start slapping force majeure clauses in everywhere. It can literally cause you more harm than it does good. It's just as likely to be used against you as it is to be used by you, right? Okay. Refund requests. This is a big one. So much is being canceled. So many things are being moved, from everything from graduations and weddings and other festivals and concerts, to even smaller events. And so obviously there have been an extraordinary amount of refund requests and cancellation requests. And a lot of clients of mine are saying, well, my contract says it's non-refundable, and so I'm not refunding it. Or people on the other side have taken that position. And here's where that's possibly problematic. Ordinarily, that's completely fine. But during a pandemic, it could be held to constitute an unfair business practice if somebody cannot use your services and you're not refunding their money. And in fact, we've seen a pretty significant spike in the filing of unfair business practices cases, just on the basis that people are not being allowed to terminate services that they can't actually use. And this could be anything from ongoing gym memberships to, one-time hair and makeup for somebody's wedding or graduation, right? So the end of the inquiry used to be, do I have a clause in my agreement that allows me to hold on to this money in the event that they cancel? That used to be it. If the answer was yes, you were fine. Now it bears being a little bit more thoughtful, because you don't want to find yourself facing an unfair business practices case. Okay. Employee accommodations. This one is going to be very, very tough for anybody with employees. So, employers are already required to make reasonable accommodations. And now you've got a situation in which you might have people who are older, who are, less apt to come back into work, who either don't want to work or want to be able to work from home. And then you may have other employees, probably predominantly women, who are willing to come back but don't have healthcare support. So if you start issuing blanket policies that, okay, it's time for everybody to come back to work, and basically terminating people or forcing them to quit if they are not willing to do so, and if that decision disproportionately affects a protected class, say women or people over the age of 40, you could find yourself facing a discrimination suit. Even if your intent wasn't to discriminate, the effect of your policy was discriminatory because it overburdened one protected class of people. So you want to be really careful crafting policies and dealing with employee requests. You want to be really thoughtful about it. If you have any concerns that the policies you're implementing about employees who are returning to work, you should definitely just speak to counsel and iron out a written plan. With all of these things that I'm talking about today, and all of these things that are going to happen, putting things in writing, like per usual, is the name of the game. So you want to have a written plan so that you can stand behind it later in case somebody sues for discriminatory policies. Okay, PP&E. There are some jurisdictions that are requiring employers to provide PP&E to their employees while they work. The problem with this is they're not really defining PP&E. And of course, we've all learned, often the hard way throughout this, that the quality of PP&E can vary greatly. So, are you required to buy the medical grade PP&E? Probably not. But are you required to, but you're probably not going to be able to get away with the whole trash bag things that you've seen some healthcare workers wearing. It probably needs to be something in between that, and it's probably going to be jurisdiction specific. Some areas may have defined it, saying, okay, you do have to do masks and you don't have to do gloves. Others are just using the term PP&E and requiring that you provide it without further defining it. And so it's going to be up to you and your counsel to decide what your risk tolerance is and whether or not you should, what you should provide and what quality that PP&E needs to be. Okay. Brief note, during the pandemic, when everything was shut down, statutes of limitation were what we call tolled, which is like a giant pause button, saying that if you had any claims, you can't use a court right now. So your time on your filing limit to file your case is not going to expire while the courts are closed. They officially unpaused that on May 29th, which means your statute of limitations was only tolled for that amount of time, right? For the amount of time that basically everything was closed up, and specifically the courts were closed. So if you have any questions whatsoever as to whether you're getting close to blowing a statute of limitations, definitely talk to your attorney. Okay, so this one I'm actually just going to read because it's a little bit complicated and lengthy. I already briefly talked about employees returning to work, to the extent you're picking which employees return to work and whether they have to wear PPE when they return to work. Now I'm going to talk about the actual return to work policies. So once you are bringing employees back, you need to take appropriate steps to protect yourself and to protect them. Governor Newsom has already issued an order stating that if an employee of yours comes down with COVID-19, there's a presumption that that employee got it while working for workers' compensation purposes, allowing them to get workers' compensation for it. So the onus is going to be on employers to actually do everything that they can to prevent their employees from getting sick. So these are the best practices, and these aren't all of them. There are more if you want to be extremely careful. And if your risk tolerance is a little on the other side, then maybe you follow less of these. But these are your best practices for how to bring employees back. So number one, you need to understand that you actually do have a legal duty to take reasonable steps to protect the health of your employees. There are 5 or 6 regulatory schemes that already impose that on employers. And it's something that, let's say, manufacturers and loggers and anybody else in an industry where physical danger is ever present. Those industries are already quite aware of what these regulations are and to the degree to which they've got to take steps to protect their employees. But ordinary office workers and retail and restaurants and coffee shops probably were not aware prior that they have an ongoing obligation to protect the health and safety of their employees. So these things are very real, especially now in light of COVID. You really do need to take steps to protect them. So that's number 2. Conduct a basic risk assessment, hazards, places where germs can transmit easily. Places where lots of people might be walking through, things that a lot of people might be touching, anything that you can do to just minimize contact and minimize people standing close together and touching the same things. You should then update your written health and safety policies. I know most of you don't have them. Probably most of my clients do not have written health and safety policies, even though you are actually supposed to have those, COVID or not. This is probably, if you don't have them, this is probably the best time ever to go ahead and take care of that. Having a written policy is so protective because in the event that you do ever get sued down the road and somebody in a deposition says to you, now, isn't it true you never even had a written health and safety policy? You don't want to have to say yes. You want to say, no, actually, we did have a written health and safety policy and we updated it with regard to COVID, right? Just having it could be hugely protective. I mean, you should use it as well, but definitely have it. You should also draft a COVID-19 testing, tracing, and disease management protocol. What's going to happen if you find out one of your employees has tested positive? What was going to happen if you find out one of your customers or clients has tested positive? What are you going to do? Are you going to require anyone that interacted with that customer to get tested? And then does the entire office staff need to get tested? Have a written plan and make sure that you do actually follow it. Because, the only thing worse than not having a plan is having a plan that you don't follow. That actually reflects upon you to an even worse degree. Document everything. Document all of these steps that you're taking. Document the process of documenting. Just basically get your plan down and get that, like every time that an employee has symptoms, document it. Document the recommendation that they get tested. Document, what their test results were. Document if they had a fever, right? All of these things. Obviously you're going to need to train your managers to comply with all these new policies that we're creating. Hopefully not new, hopefully just updated policies. But even if they're new, make sure your managers are actually trained, because that's another thing you don't want. A manager sitting in a deposition saying, I've never heard of a health and safety policy before. And then finally, you're going to want to stay up to date on changing recommendations. And I understand that this has been a bit of a nightmare. First, it was nobody but healthcare professionals should be wearing PPE, and then it was everybody should be wearing masks, but maybe not gloves. And it was like, okay, definitely not gloves. Meanwhile, the WHO and the CDC had contradictory recommendations. It was originally thought that this was spreading primarily through touching of surfaces, and everybody went crazy with the hand washing and the sanitizer. And then it was like, no, it's through breathing, but it's the asymptomatic people breathing, and that's how it's spreading primarily, because they don't know that they have it or they're pre-symptomatic. Now the latest data seems to say that actually the asymptomatic and pre-symptomatic people aren't really spreading it too much. Kids might not be spreading it at all, and it's actually the sick people doing most of the spreading, right? I understand it's like a moving target, and it feels like something that you can't quite grasp, and it feels frustrating to have to constantly pivot and face these new recommendations and adjust your practices, but that's just the state of the world that we're in right now. It's a novel virus. We're going to continue to learn about it. We're going to continue to study it. We're not going to have this thing nailed down for a while. And so I think you have to get comfortable with a little bit of discomfort here, and just know that you're going to have to be changing all of these things as new information comes in, as new peer-reviewed data becomes available, and as new CDC/WHO recommendations come out. California issued a Cal-OSHA interim general guidelines from protecting workers from COVID-19. Has some really great info. Highly recommend you just Google that. You can also, if you want to sign up for my mailing list, I can send it to you. Or just shoot me a message. So I highly recommend taking a look at that if you've got a lot of employees, and taking all the steps recommended. But yeah, that's basically all I wanted to talk to you about today. It's gotten a little bit longer than I expected, but hopefully you found this useful. And I'll just have to say, this is a rapidly changing time. The people who stay flexible and take proactive steps every time they receive new information are probably the companies that are going to come out ahead. And so, work with your counsel to stay out ahead of this, to identify your areas of risk, to take whatever steps are reasonable and not cost prohibitive, because some of them might be. And hopefully you'll have a smooth reopening with no issues and no lawsuits, right? Because the COVID-19, I got sick at your establishment lawsuits are already through the roof. And this is just the beginning. So a little bit of proactive legal planning could save you so much money down the road. Everyone stay well, stay safe, and good luck with the reopen.